Hello, I'm Jane Flemming, a Senior Associate Solicitor in the Family Department at Astle Paterson Solicitors. Financial settlements are agreements reached between divorcing couples whereby they decide how they're going to split the assets between them. For example, there may be properties, there may be pensions, there may be savings or other investments or business assets that they may wish to share between them. And a financial settlement is an agreement setting out how these are to be divided between them. There can be orders such as property adjustment orders, whereby one spouse may transfer one property to another and provide a lump sum for their share, or it may be a pension sharing order where a proportion of one party's pension is paid to another as a pension credit and then forms the pension in their sole name, or it might be a lump sum payment or a spousal maintenance payment. When deciding a divorce settlement, you do not always have to go to court. More often than not, parties will settle matters outside of the court arena. So you can either decide it between yourselves or instruct lawyers to negotiate on your behalf, or alternatively, you can go to mediation, which is something the court would expect you to do in any event before making an application to the court, in the hope that matters can be settled without the need for court proceedings. You may be worried about attending court if there is no other option but to start court proceedings. The first hearing is usually by video link, so you do not have to even go to the court building, and all parties and the judge will be on the screen in front of you during that hearing. At the second hearing, parties normally are expected to attend court and negotiate a settlement with the help of a judge. At that hearing, you will go through security initially, and then there'll be a waiting area where you wait and negotiate there before seeing a judge, and then possibly negotiate after the hearing also, in the hope that you can reach an agreement. If no agreement is reached, the judge will list the matter for a final hearing, which you will have to attend, and evidence may be asked of you before a final order is made. When parties reach an agreement, they enter into what is known as a clean break consent order. This will set out the agreement reached between them, and it will be in full and final settlement. Without such an agreement, both parties are at risk of further claims. Say, for example, if you transferred the house but did not enter into a clean break consent order, and then you got divorced, you went your separate ways, and then several years later, your ex-husband or ex-wife comes to your door and says, well, actually, I'd like to now make a claim on your house or your pension. If you do not have a clean break consent order, then they can still proceed with that application. If they have remarried, they would be barred from making an application, say, for any pension claims. So it is extremely important that an application for a clean break consent order is made, even if you have no assets, as you do not know what you may accrue in the future.